There wasn't a single ruling he made that part was wrong.
Appreciate everybody being here today. Let's go ahead and get started with our House Judiciary Committee meeting today. If you would, bow your heads with me, and as we always do, start out with a word of prayer. Lord, we thank you for all the blessings that we have, and we thank you for the rain outside, and we also, Lord, thank you for the sunshine. We know we need a balance of both, and we ask for that same balance of being in this room now as that we try to weigh the measures before us and do what is best for this great state. Thank you for all these blessings that we do have. Amen. Representative Clark, you want to come on around to the front, and we will turn on your witness microphone. For those who have been following Representative Clark's bill and issue, late last year, a special subcommittee met to have, I guess what was at that time, a day-long hearing, if I recall, and multiple witnesses. In fact, everybody who wanted to testify, which was quite a few. And we had then at that time discussed that we would come back later and revisit Representative Clark's bill, and that time is upon us today. And I know, Representative Clark, you have made some changes,
yes, sir,
to the bill, and I also know that you have an attorney coming from the center in Athens, I believe, and she is parking and on her way, so she'll probably come in. But because we have meetings going on all across the Capitol, I just had to leave one myself. I intend to try to use our time very wisely today so members can get to other locations where they may have to be when we finish. So, having said that, Representative Clark, if you would begin to walk us through the bill substitute, and I have LC 28-97026 in front of me.
2S.
I'm going to tell you what. Hold on one second. What he said. And we'll work from that, but why don't you begin to tell us about the substitute in front of us and walk us through it, if you don't mind.
You want to go through the whole bill or just the changes for this?
Well, since it's been a minute since we talked about it, why don't you just give us an overview of the whole bill and the parts and what they do, and then we'll talk about the changes as well.
All right. So Section 2, the changes here with this bill is it changes from the time of discovery from a 2-year window to a 4-year window in line 20. That if there was abuse and such abuse resulted in injury established by a medical professional, that from the time of discovery there would be a 4-year window. It also, on over to page 2, lines 31 through 33, if an act is committed on or after July 1st of 2020, the plaintiff is between the age of 23 and 52. That's one of the changes. The previous version had 38. The substitute raises the age to 52 because during the testimony phase from that special subcommittee, we had the evidence and science shows that the age of discovery is the average age of 52, so that they may bring civil action for recovery of damages suffered as a result of child sexual abuse. So that you wouldn't even have to have that 4-year window of discovery between 23 to 52. Going on down, in Section 3, it defines entity as a agency, firm, business, corporation, or other public or private legal organization. And there's just some definitions here of person, responsibility for care.
Representative Clark.
Okay, you want to go ahead and come on up here too?
I'm so sorry I'm late, you guys.
This is Emma.
We don't allow
Hetherington.
anybody to have a rest when they get here. We put you right to work.
That's okay.
And I want to say professor,
Yes.
and please remind me of your full name.
Yes, Emma Hetherington. I'm an assistant clinical professor at the at the University of Georgia School of Law. I'm also the director of the Wilbank Cease Clinic, where we represent survivors. Really are putting me right into this. Survivors of child sexual abuse in both civil and juvenile court proceedings.
And you're an attorney, correct?
Yes, I am.
Okay. And Professor, just to let you know where we started, Representative Clark just started walking us through the bill in front of us, and I said, go ahead and remind us of all the sections in the bill,
Okay.
and point out specifically the changes. And after he did that, we'll probably come back with questions.
Okay. All right.
And do you have a copy? And do you need a copy?
I do have a copy
Professor,
of the bill.
okay, thank you.
Yes.
I'm sorry, Representative Clark, go ahead.
And then in line 68, this is the look back, to go and look back to organizations or entities and file for civil damages that are suffered as a result of child sexual abuse. If the statute of limitations, so the change in this section would be on line 82 in this substitute. If you look there, it says that the action or inactions occurring on or after July 1st, 1973. And the reason for that date is that is the date where the mandatory reporting laws included organizations and added them to the list. So that's the reason for that date. That at that point it was clear in the law that if something happened, you knew or had suspicion of something happening, that there was a requirement to report to the law. So, and then it just sets up, the rest of this section sets up what had to happen for, and the level of burden of proof to file and have this action. So, and then lines 108 and 109 are the other changes, that it is a waiving of sovereign immunity and government immunity. That is needed because, as we defined an entity or organization being public or private, if the organization is a public organization, though, that is necessary for a plaintiff to be able to file an action. So.
Professor, what I would like to do at this point, and you may be able to help us with this, as I mentioned, it's been a little bit since the committee has talked about this, and when I mean we've been chatting about this issue, passing laws on it for 4 or 5 years now at least, and every time we bring the issue up again, I have to remind myself of all the iterations that have come before this and what the law used to be and what we changed it. Now, I don't want to ask you to, well, let me go ahead and say, can you walk the committee through, because I believe you're familiar with, in Georgia, some of the changes that we've made over the past 5 or 6 years maybe, is in where we are now, and then I'd like for you to compare that to what this bill would take it a step further, if I may use that term.
Sure, absolutely. So prior to 2015, the statute of limitations since 1992 for child sexual abuse claims was 5 years after age of majority. And then in 2015, what's colloquially referred to as the Hidden Predator Act was passed, and that would be what is current law now. At the time, what it did was it didn't change the law in terms of allowing survivors to sue up to the age of 23. That stayed. There were 2 additions that were new. One was a delayed discovery provision, and that delayed discovery provision allowed survivors to file suits over, and these survivors would have to be over the age of 23, and also their abuse would have had to occur on or after July 1, 2015. They could file it within 2 years of the discovery that the child sexual abuse caused the resulting harm, so all the psychological and other harms that may come up. The other addition was an open window, It was limited. It was a 2-year open window. It closed June 30th, 2017. And that window allowed for only lawsuits against perpetrators themselves. And it specifically excluded any entity liability. And so as of now, under Georgia law, what we have is a survivor can sue either prior to their 23rd birthday, or if their abuse occurred on or after July 1, 2015, within 2 years of the discovery that the abuse caused the harm. So that's current Georgia law.
Against the perpetrator.
Against perpetrators or entities.
If you're not 23 yet, and what was the other trigger?
For those over 23
Mhm.
and who were abused on or after July 1, 2015,
Okay.
they could sue within 2 years of the delayed discovery that the abuse caused the harm.
So really, and I don't want to say this the wrong way, we made the change to the law prospectively going forward.
Yes.
And really what we're dealing with it today, to some extent, is looking back to what the law used to not be and how we might now retroactively, so to speak, change it. Is that right?
Yes.
Okay. All right. Go ahead. I'm sorry.
And then, so with the bill that's before you right now, the substitute, there's a few changes on there that Representative Clark has already discussed. One would be that delayed discovery window that I mentioned before would be expanded to a 4-year window.
And tell us what you're on line 20 now.
Sure.
Okay.
It's line 20 is where it begins. So for those who are over the age of 23, and again, who were abused on or after July 1, 2015, they would be able to file a claim within 4 years of the discovery that the abuse caused the harm.
So basically a 4-year statute of limitation, basically, after discovery.
Yes.
Okay.
Yes.
And the term discovery, particularly in this context, means that in instances we have heard of, these incidents are suppressed by the individual, but at various stages of life, whether it be adulthood, or marriage, or having children, sometimes they're triggered. Is
Right.
that an accurate
Yes,
summation?
that is absolutely accurate. Within the report, I don't know if you all received a copy of it. I know it's very long, and I will be submitting after this hearing a shorter, much nicer executive summary for you. They'll be easier to see these fast statistics. But you can see in the report, there is, starting on page 18, there is some information on repressed memory and false claims. One of the things that we know is that the average age that a survivor of child sexual abuse will realize that the abuse caused resulting harms is age 52. We also know that the majority of survivors of child sexual abuse do have some level of repressed memory or dissociative amnesia related to that trauma. It's very akin to, say, a veteran who is in combat and suffers post-traumatic stress disorder. It's the same sort of mechanism in the brain, the same neurobiological functions that are impaired and that can affect memory. So a delayed discovery window allows for a survivor to come to that realization. And then therapeutically, also, the longer a delayed discovery statute of limitations is, it gives a survivor more time to be ready to go through a civil lawsuit.
Okay.
So starting on, excuse me, another significant change would be starting on lines 31 through 33. And that would be that going forward, so new abuse that hasn't even occurred yet, so that occurred is currently written on or after July 1, 2020, survivors would be able to file claims until the age of 52. And I believe, my understanding is that age of 52 comes from that as the average age of disclosure of that sort of delayed discovery, because we know that only a third of children ever disclose that they were sexually abused, meaning that most will disclose in adulthood and many never do disclose.
So basically what that would mean is going forward, after this would become law, if it did on July 1st, 2020,
Right.
that the statute of limitation actually ends at age 52.
Yes.
And that would supersede the previous paragraph, basically, for all acts after 2022. When I say previous paragraph, I mean lines 20 there.
starting at lines 20.
Mhm.
So that is a question that I have on construction.
Yes.
And I think that there may be some cleaner ways to construct this, but
Okay.
if we are raising the age, the question that I had was, well, would the intent of of this committee and of the legislature be to then get rid of a delayed discovery provision, or would it be to allow for a delayed discovery provision, but the way it would need to be written going forward would be for individuals over the age of 52? And I believe that was more the intent when, in speaking to Representative Clark. Again, 52 is the average age of disclosure. It's not the oldest age of disclosure. This is just an average.
We probably won't have time to work on that.
Yeah.
So, yeah. All right, go ahead.
So that would be one. And I think another important thing to note that you had mentioned was that plaintiffs survivors with the ability to file a suit up to age 52, those are for survivors who have not yet been victimized.
Right.
And I think that is important to note, which brings us to the other significant change here, that open window, retroactive open window provision. So what we see in other states is where a legislative body determines that it wants to raise an age by which survivors can sue, there's an acknowledgement of there are a lot of current victims, current survivors who will not be able to take advantage of this new law going forward. And so opening up these retroactive windows is the legislature's way of saying, we recognize that there are probably hundreds of thousands potentially of survivors that will never be able to access civil justice. And so we're going to open up this limited window during which time the survivors that will otherwise be barred going forward will be able to file these suits. So that's the purpose of those windows that we see in other states. So the proposed window starting on line 68, as currently written, would be for a period of 1 year, so starting July 1, 2020. And this would allow survivors of any age to file for civil recovery. This retroactive provision does allow for claims against both the perpetrators and then also entities with a specific type of liability. This provision, so starting at line 76, the entities with that responsibility of care, they have to knew or should have known that the conduct gave rise to civil action, and that their actions involved harboring, assisting, concealing, or withholding information about the person. So it's a higher standard. I have not seen this specific language in other state open windows, but there are some other limitations that other states have done as well. But this would, I think, allow for some of the concern is what about organizations that did not know that this was happening and that did not proactively hide this person or with conscious disregard ignore the reports of abuse. So I think that addresses that concern from what I can tell. And then below are starting at line 80, as Representative Clark mentioned, this would only allow the open window provision to allow claims against entities where those actions or inactions occurred after July 1, 1973. And as Representative did correctly state, our mandated reporter laws here in Georgia prior to 1973 were more specific to medical professionals. And so organizations such as Boy Scouts of America or the Catholic Church would not have been mandated reporters prior to 1973. And so again, I think that addresses some of the concern of if we open this up too much, it's going to cause chaos, or we're going to go too far back to when organizations and individuals were not mandated reporters, and therefore their failure to report, it would be more difficult to say that was breaking the law at the time. Some other notable changes would be for entity liability, that the burden of proof would be clear and convincing evidence rather than by preponderance of the evidence. I have seen this in a couple of other states as well. Most states do not opt to raise the burden of proof for survivors. They already have that a very high burden of proof with the harboring, assisting, transferring, etc., but that's not completely abnormal or unseen in other states. Excuse me. And then there's also, starting on line 97, information there about when the entity is an unincorporated association. This would keep members or owners not from being personally liable if they were not part of this negligence. So that would be another piece of it. And then also the last piece, lines 108 and 109, waiving that sovereign immunity and government immunity so that claims could potentially be brought forward, brought against public schools, for example, where we do know that there has been a lot of attention recently and revelations of abuse among teachers and school administrations knowing and things of that extent. The other limitation I think is really important to note starts at line 102. So this is on or after July 1, 2021. So this would be when that retroactive window would close. And this, I think, is constructed in a very confusing manner and could potentially cause some appeals and a lot of confusion in terms of when and who can file these suits. But saying in addition to the extended periods of limitation, when an entity had a responsibility for care of the plaintiff, the recovery for damages has to be filed within 1 year of the date that the plaintiff discovered evidence that the entity intentionally or with conscious indifference concealed evidence of the abuse and the conduct alleged in the action. And my concern there is that the effect of this, one, it's confusing because of the words in addition to, and two, the effect of this may mean that if someone discovered the entity had intentionally or conscious indifference concealed evidence of the abuse in that conduct, if they are under the age of 52, then their statute of limitation only becomes 1 year. So that's another sort of hiccup in the way that this is drafted that I think would potentially have a detrimental effect on survivors.
Go through that one more time.
Okay, sorry, it's a little confusing. So starting on line 102, what that provision would do after the closing of the retroactive window, it would require survivors who have discovered that an entity intentionally or with conscious indifference concealed evidence of the abuse and the conduct and the abuse in general, they would only have 1 year to file a claim. And so if say a survivor were 34 and they discovered that this organization knew about the abuse, they hid this person, he'd abused other people before, they could have prevented their abuse, they allowed this person to still be around children, all of those things, they would only have until they're 35 to file this claim, whereas everyone else would have until they're 52. It's just the quite frankly, the dumb luck of figuring this out earlier than other people. So I think the effect of that provision could be very damaging for survivors.
Okay. Alrighty. What I'd like to do now is, Ms. Oliver, you have a question? What I'd like to do now is let the members ask questions of Representative Heath or Professor Hetherington.
Yes.
I'm going to write it where I can read it this time. Professor Hetherington.
Thank you.
Questions about what we've just discussed. Ms. Oliver?
Thank you very much for this work. This is really impressive.
I'm aware that after the 2015 statute was passed, there were various filings, and the issue of the entity being potentially liable has been litigated without a statute. And I'm trying to figure out, if we pass this, is there going to be retroactive opportunity to pull those entities in? And it kind of ties into a little bit of your question about paragraph 4, 102, I think. Trying to figure out if we can help those victims and entity defendants based on our 2015 and thereafter lawsuits since then.
So, as you stated, there's been a number of lawsuits since the 2015 law was passed, although a pretty small handful. I think
14?
Something along those 14,
17.
15. And it's hard to count because some of these lawsuits are not just against the entities, they're also against the individual perpetrators. And the causes of action that are being utilized in these lawsuits range from the open window under the Last Hidden Predator Act as against a perpetrator, or in some cases, public nuisance claims against organizations for causing a public health crisis that's child sexual abuse.
I
So
was
there's a number of
aware
things.
there were other avenues to go after the entity, and I don't know whether any of that's been successful. But setting aside the
Hold on one second, Representative, because to that point, and maybe the professor can comment on this, it's my understanding that there is a series of cases where a Superior Court judge ruled that they could proceed under a fraud theory. In other words, that
Other tort theories.
the harmful action was willfully concealed. Therefore, the sun never sets on fraud, that little phrase that we learned in law school. And that is currently before the Court of Appeals, her ruling, the judge's ruling. Is that correct? Are you familiar with that?
Yes. So there are, as I mentioned, there's a number of other theories that were out there. What I would say is that if this committee were to, and I can't endorse any specific legislation, obviously, but if this committee were to open up a window or to allow survivors to sue later, I think it would help clear up a lot of the confusion, because there have been different superior courts have answered these questions differently. And so that is causing more litigation, right? That is causing more confusion in our court system. So that's been the effect of that.
But if
I'm
the Court of Appeals rules in favor of that fraud theory, then all the courts would now have direction as to how to handle if you show a willful concealment or willful
under this high
concealment.
standard. Let me just follow up, because I want
Please.
to make sure I'm. The issue of litigation recovery against entities has been in litigation in many or all of the 14-ish lawsuits, and there have been inconsistent trial rulings.
Mhm.
The Court of Appeals decision, does it cover all the fraud theories, or fraud and nuisance?
They haven't ruled yet, I don't think.
Yeah,
But, excuse me, the Court
It's
of
before them.
Appeals. Is there one case before the Court of Appeals?
There's one case before the Court of Appeals.
There are others
Several
on the
incidents in
line.
that one case, yeah.
Yes, and there's fraud theory, public nuisance, RICO. So there's a number of theories there that potentially survivors could go forward on. There's a court in Floyd County that said that claims could go forward under those theories, and they were able to, the plaintiffs were able to defeat motions to dismiss. They will still likely face motions for summary judgment and all that, but there's, like I said, there's a split right now.
So if that is upheld favorably to the victim, hypothetically, that means that the folks in that litigation would not have these higher standards against the entity. They would be on traditional tort theory liability. I just want to make sure I understand it. And if we can decide either to gamble on what that decision does or doesn't do for victims, and it'll probably go to the Supreme Court, and maybe even, or we can make a policy decision on retroactivity based on the 2015 statute. And I'm really thinking, I'm thinking aloud with you as to, do we want to gamble on what the Court of Appeals does, or do we want to resolve the issue here? And I'm just questioning.
So I have a couple things to that. So in terms of a fraud, as you mentioned, proving a fraud case is very high bar, and it's very difficult for survivors to do that. Also, with the public nuisance and RICO claims, same thing, very difficult to do that. I believe in only one, maybe two states, those have been public nuisance and RICO avenues have been successful. In most other states, though, the appellate courts have said, no, you can't bring this forward, and we need the regular statute of limitations on child sexual abuse to allow these actions to go forward. So I think it is a gamble when you look at what other states have been doing. And we, at this point, have no idea, obviously, what the Court of Appeals will decide.
Or the Supreme Court.
Or the Supreme Court.
Or the Georgia Supreme Court.
Because likely it will go to the Supreme Court, is my guess.
Mr. Welch.
A couple of questions, if I may. Number one, if we tend to, I think we talked about this last week. I think Representative Oliver had brought this up last week, that this committee tends to avoid engaging in lawmaking that may affect pending litigation. And so if we did do this, because it is retroactive, I mean, then it would have that impact of affecting that particular suit. So I raise that as a concern. We tend to not do that. That is the other thing is the language here at 107 has me concerned, because I think that is fairly broad, in that what intent, well, beginning at line 106, it says entity intentionally or with conscious indifference concealed evidence. Well, concealing evidence could be that the documents that were pertaining to the activity were shredded because they were stored, or they were, and someone, someone shredded them or destroyed them. So concealing evidence gets into this issue of, was the intent to destroy or disregard or throw in the wastebasket or just lose the evidence? Was it the intent to lose it, to shred it, to dispose of it because it had been sitting there for some period of time, a lengthy period of time, or was it the intention of the person to dispose of the evidence because they didn't want the evidence to be used against someone? And that creates a problem for me, because I can envision these entities that have been around for a long period of time having boxes of documents that have been, may not be, we don't know where that is, photographs or other things like that. Now, to think that they would have kept anything like that is problematic in my own mind from a moral standpoint, but I'm concerned about how this plays out in litigation.
Sure. So I think in terms of proving intent, it would be fairly straightforward. You would want to look at, courts would probably want to look at what are the regular business practices for destruction of files in their offices. For example, in my office, after we keep physical files for 6 years, we shred them, right? So this is a regular practice that we have. It's written as a policy. We always do this. It's not we got hit with a lawsuit or we think we might, now we're going to shred these things. So I think that the timing of when documents may be shredded, because I agree, that is a regular practice in many organizations and institutions, but if it is your regular practice, you can show, well, we do this for everything. It's not just these files. And what we have seen, especially in the case of Boy Scouts, also Catholic churches, they did keep documentation, and they kept it for years and years and years, and there's likely more that we haven't even seen at this point, because the released files, at least from the Boy Scouts, ended in the 90s. We don't know what they may or may not have post the 90s. So, I think it's fairly straightforward as long as you can show it's a regular business practice and not very curious timing, and only happened once, then I think the intent piece can be there for that. But I do agree. And there are other cases. There's a school up in New York, Horace Mann School, where conveniently when survivors started coming forward, there was a fire and everything was destroyed. So, right, so you see, I'm not saying they did it purposefully, by the way, but you see things that are precarious timing. So that would be my response to that. And in terms of legislation that affects current litigation, since the current cases are filed under other legal theories, I don't think that they would be currently affected in going forward on those legal theories. I think that they would be kept from filing if they completed the litigation in whatever form that may be, a settlement or a jury finding. I think that they may be kept from filing under an open window under this legislation, this proposed legislation. It wouldn't stop them necessarily from dismissing their current claims and then refiling under this. Right. So I don't really know what the effect of. I don't think it would necessarily affect the current legislation so greatly. I think, again, they'd either go forward under their current theory and go that way, or dismiss and refile.
Or file under the other theory.
Right.
Yeah.
Right.
So just be a new cause of action, new complaint.
Right,
Yeah.
exactly.
Yeah, so, okay. That's all for right now, thanks.
Okay. Let's see. Is that Mr. Dreyer?
Thank you, Mr. Chair. I don't think I will take too long, but I have two different kind of lines of inquiry, if I could. The first is going to what you said about Ms. Hetherington about the pending legislation. I mean, it seems to me that there are these parties and attorneys that are trying to cross this river, and instead of being able to get on a boat, they have had to, find what sticks and duct tape was lying around and patch it together and try to get across. But there is a regular way that people could proceed and have proceeded in other states, and it's legislation like this. Would you agree with that?
Yes, I would agree with that. And in the report that I provided, starting on page 10, I do discuss various statutes in other states. Several have passed new legislation since 2018, 2019, and then also there are a number of bills on the table in various states this year as well. And when you look at those trends, also something to point out is that in Georgia we're very behind in terms of survivor rights when it comes to civil remedies. We have been named as from Child USA, which is a think tank that works in legal issues related to children and affecting children, as one of the worst states in the country for our civil statute of limitations. And that is a reputation that is growing and that we do currently have, because we do have a very limited statute of limitations. Only 6 states, us included in Georgia, require claims to be filed sometime before the age of 30. Every other state in the country will allow claims after the age of 30. And the ages vary depending on the state. There's some random numbers out there. There's some more research-based numbers out there. But I think that is important to note, and for the committee to know, is legislation like this would put us more in line with what we see nationally.
Mm-hmm. Thank you. And I did have a different interpretation than the one you gave earlier of lines 102 through 109. Rather than it being an additional limitation, I see, if we look on line 102 towards the end, it says, and in addition to the extended periods limitation provided by this section. So the in addition to, I think, rather than being a limitation, would, just on my reading, actually open it up for survivors when there is that active concealment. Am I reading that wrong? Because with the in addition to would be in addition to the other remedies provided here, right?
So I mentioned before, I think this is where some of the confusion comes in, and I think that in addition to language makes it confusing. I think you could interpret it either way. You could say, oh, this is an additional, maybe in the future anyone could file as long as it's within 1 year and there's no age limit on it. You could read it that way. Or you could read it as, well, this is another limitation that's going to be put on top of the other ones we already have as well.
How do you read it that way?
How do I read it that way? Because it's saying that the plaintiff shall, so the civil action for recovery of damages suffered from childhood sexual abuse shall be commenced within 1 year from the date the plaintiff discovered evidence. It doesn't say after the age of 52. It doesn't say otherwise. That's where I worry an interpretation could come out. And that if I were a defense attorney on such a case, I would argue that that's what it means.
And if you weren't, you would argue that line 102 and 103, where it says,
Right.
and in addition to the extended periods, in other words, this is something on top of what we've already given you.
Right.
Okay.
So I just meant to say, to clarify, that it can be read 2 different ways, and I think it could be confusing.
Mm-hmm.
And it does lend open for some future arguments and possible appeals on the language.
Potentially. And one last point, if I may, Mr. Chairman. When we are talking about concealed evidence, I agree with your point. Most entities have a document retention policy. It's on file. Tapes are recorded over or erased, not in 6 years, but within several days for the most part. And so I think most have those. And when the court cases I've seen on concealing evidence are specifically Ford having insurance policy that they're not disclosing when specifically asked. That's the kind of concealment I'm thinking of. And when you mentioned the Boy Scouts, you mentioned there was a file of the list of every sexual predator and how many different dens they had been in, and that was not produced when required. That's the kind of concealment I would tend to think of. Is that right?
Yes.
Mr. Walensky?
Thank you, Chair. Thanks for bringing this bill. I just have a couple questions regarding some of the sentences. Line 73. It says, a person who had a responsibility, and I'm reading that as any responsibility. Is the intention to be that broad?
Not my reading of it. I mean, I would, in full, the responsibility for care. So that legal duty of care you would have to have. And currently under law, if I were to file a negligence claim against an entity, I would have to prove that duty of care in order to go forward with that claim anyways.
And in line 63, there's a definition for
great.
responsibility
Right.
of care.
Good.
Is the
Great.
person
Okay. Thank
Yeah.
you. All right. Lines 76 through 78. The A has a preponderance of evidence standard. What standard are we giving to Part B?
Where were you at again?
Lines 76 through 79. You specifically in Part A, 73, 75, you specifically say
Representative
that,
Wentz, repeat your question.
am I mumbling? I'm tired.
No, the door caused some people not
Thank
to be able
you.
to hear over here.
All right.
So I do have an answer for you.
Well, he
hold
wants
on,
me to repeat
the
the question. All right.
first.
Lines 76 through 79, I'm asking, what is the standard of that? Because I see line A specifically designates that as 73 through 75 as having a preponderance of evidence standard. And so I was just wondering, what standard do we have for that part?
Sure. So that is starting on line 93, and it does kind of skip down a little bit. But line 93, that is 3B. It refers back to 2B, and says that the standard would be clear and convincing evidence.
Okay, thank you.
And I do want to announce, I was looking at the sign-up sheet here. We have a couple of folks signed in to testify on House Bill 915. We will not be hearing that bill today. And just want to make sure that you knew that. And I just recognized, I would have told you earlier when I saw you walk in. You may be excused, absolutely. But everybody else has to stay. Thank you.
Chair, I have just one more question.
Please go ahead. And I'm sorry to interrupt you.
Oh, no, may I be excused after two?
No, you may not be.
All right. Thank you, Chair.
We had that problem earlier.
Yesterday was great.
Go ahead. We're trying to interrupt your train of thought, but you're going to
I've never
succeed.
been
Have
told I was
confidence in
perfect.
you. Yeah, that's right.
All right. Lines 99 through 101. Starting part, section C. All right. So when an entity is an unincorporated association, the individual members pretty much say have no personal liability. However, then it says, unless such individuals' own actions constitute negligence by being a deviation from the standard of care that an ordinarily prudent person would exercise in that like position. My question, it sounded like your example before, this would be an intentional act, not a negligence act. And my question would be, what duty would a person have if at first we're trying to say that they're not personally liable, but then we're applying a duty to them and trying to understand how that paragraph's set up?
Sure. So I think what I think what this paragraph is doing is just saying those individual members are not going to be liable unless they would otherwise be under Georgia law, because in terms of negligence law, this would be negligence, right? So we're looking at a negligence, the regular negligence standard here. So based on what was their duty of care and what was that ordinary prudent sort of standard that they were supposed to be acting under for someone in a position similar to them. So are we talking about someone who is directly responsible for the care of children? As an example, right? So we would have to then probably look to our negligence laws in the state of Georgia, and you would just revert back to laws that already exist and case law that already exists there. So I don't think this actually changes much.
The purpose of subsection C inside of this is dealing with the covering up, as we were saying. Mm-hmm. And to put what an ordinarily prudent person would do from the standard of care, that's turning a situation of damaging evidence and stuff like that into their care of the individual. I maybe be the only one, but I think it sounds like it's an intentional act, and I just have concern about having a negligent standard of an ordinary prudent person in a like position. I just don't read this in a good way, and I may be the only one, but it's a little confusing to
I
me.
see what you're saying. So, no, and I agree with you. It is a different standard than what is memorialized under 3A. So all of those failing to report, harboring, transferring, moving, intentionally with conscious indifference, etc. I think it is different. So I think what this is saying is, again, for an individual member or owner of an unincorporated association, you would look at just regular negligence law.
So, I may be, last question.
Yeah.
Hopefully. I'm a lawyer. There you go. Always last question.
Yep.
Is the intent here to say that they're not personally liable unless they acted in part of the fraud?
So I don't know if that is the intention of what this bill wants to have included. Then that would be another question. I didn't write this, so I don't know what the intent behind this is.
So I'm reading this as I'm getting a head nod, and I've never met her before, but if that's the intent, I think we need to work on the language of 99 through 101, because putting a negligence standard on a care of a person and then it doesn't make sense there. That's all I got.
Okay.
Thank you, Chair.
All righty.
So I'm so sorry. The one
Sure.
difference I would say that does exist here is this subpart C is talking about the individual people, not the entity as a whole. And so that is the major difference. Maybe, again, I agree, if the intent is to have a higher standard for those individual people, then it should be there. If you look at the standard against individual perpetrators, right, it's going to be different than entity liability. So again, I don't know the intention behind it. I didn't write it. But I agree, if the intent is supposed to be a higher standard against those individuals, then it should probably say that.
All right, Representative, if you would, maybe you and Professor Hetherington just move over a couple of chairs. But I want you to stay up there in case questions pop up. Mark B. Harrops? Barons? Yeah. We'll come back. We'll come back. Rushi Patel? Is Rushi here? Yes. Mr. Patel, good to see you. Please introduce yourself, and we'd be happy to hear from you.
Good afternoon. My name is Rushi Patel with the Georgia Municipal Association. Thank you, Mr. Chairman and members of the committee. We got a hold of this substitute relatively recently, just about an hour and a half ago. And I think some of the things, particularly in Section 3, might warrant some study from a local government perspective. Particularly when we're looking at the waiver of sovereign immunity at lines 108 to 109. When we're looking at actions as abhorrent as they may be going back a few decades, that may have been committed by somebody who volunteered for a city a few decades ago, and we're waiving sovereign immunity for those actions that may have happened in the 70s, 80s, at some point in the past. We're entering a situation where the local government may end up becoming financially responsible, and the current taxpayers may end up becoming financially responsible for something that happened with a completely different leadership and a completely different employment structure from a few decades ago. And that, I think, warrants some study from a local government perspective, because it could be that that doesn't have a huge impact, but it could be that that does have a huge impact, and we just don't know right now.
Would that be similar to a situation where a church with an act that had been committed, let's just say in the 1970s, no longer has the same pastor, no longer has the same governing body? Maybe there's some members still around, but they were children or teenagers and had no leadership role whatsoever in the church. Would that be similar?
I think it's a great question. I think it would be somewhat similar. I think one difference is when we look at the Georgia statutes when it comes to local government, we try not to bind future governments for the actions and misdeeds of previous governments. And that's something in case law and statutory law, and I think that's the slight difference here.
Okay. Let's see. Mr. Wilson, is that you?
Thank you, Mr. Chairman. Mr. Patel, thank you for being here.
Sure.
I have great respect for you and your work. And I take your point But isn't it true that the plaintiff would still have the evidentiary burden, correct?
This
And
is
so if they
true.
wouldn't be able to meet that burden, and all this really does, and to the chairman's point, is give them the opportunity to gather that evidence if it exists still.
Right. That is very true. And from Mr. Walensky's point, I think it's a clear and convincing evidence standard for the entity at line 93 to 94. So.
Okay. Mr. Welch?
Maybe I misunderstood the point that Mr. Wilson was making, but I read this to say it's waived to the extent of the liability. So there's no, I mean, it is waived for the liability that would be afforded by this. So it's not, there is no other. I mean, the evidence is the evidence. That's going to be true for any of the cases that are proven, but the waiver is a waiver to open up any local government for the extent of the liability that would be found should the suit be brought. So I'm not sure if y'all are, I don't think what I heard was the same, that you two were talking the same.
I think that's a
So-
good point.
And then furthermore, I would also submit that this bill does not address the prerequisite that a claim for damages must be provided in notice for counties 1 year within 1 year of the occurrence,
Right.
and within 6 months of the occurrence. So if it is the intent of the author to modify the law and open up local governments for the full panoply of liability that may exist as a result of a claim brought, then you'd also have to look at those other code sections, because that would bar it. That's a jurisdictional prerequisite that must also be done, and there obviously is no way to do that, because the law requires that it would be brought in. Representative Chairman Clark, you wouldn't know this, but you may, but I don't think you would, that there's another code section that deals with local government, says, hey, if you've got a damage claim against a city, you have to bring that damage claim, you have to provide notice, written notice to the city of that claim within 6 months of its occurrence. And then for counties, it's 1 year.
Mm-hmm.
And so that ante litem notice would need to be revisited in this bill as well, because otherwise this waiver would be frankly meaningless, because
That's right.
I mean, as the defense for a city or county would be, well, we never got notice. We didn't get the ante litem notices were statutorily required.
Chairman Welch, if you begin line 108 with the words "notwithstanding any other provision of the law to the contrary, comma," would that solve that problem?
At line,
If you begin line 108, which is the waiver of sovereign immunity, if it began with, instead of the word "for," if it began with "notwithstanding any other provision of the law to the contrary, comma."
I don't think that, perhaps, but I would argue that, just for our purposes here, that would not be specific as to the notice requirement. And what you're saying is notwithstanding any other provision of law, the sovereign immunity, and sovereign immunity is a separate and distinct creature, a species. The notice is a separate species within the law. And so, without speaking directly to that, you'd want to say something like, notwithstanding any notice requirements that the law may provide, an action could be brought, and this would be a waiver of sovereign immunity, something to that effect. But if that's the author's intent, something to that effect, and we can do a much better job with some time.
That's point well taken. Thank you.
The other question I have about the sovereign immunity, if I may, Mr. Chairman, is
Please.
that with the waiver of the sovereign immunity, there are, in 1991, the people of the state of Georgia put in place the sovereign immunity provision. So, as a matter of constitutional law and contractual law between the people and the government, the governed and the government, the concept was that lawsuits shouldn't be brought against the taxpayers via their government, because it was going to increase the cost and liability to the taxpayers. And so I have some concerns that a retrospective effective revision and waiver of that, in my mind, has some is inconsistent with what the people voted in place to begin with. And then furthermore, that the sovereign immunity law as it existed prior to 1991 is distinctly is different, and so had different applications. So you're waiving both of it, whatever it was at whatever time you're waiving it, and I'm not sure what that ultimately does, and is that the step that we want to take?
Mr. Jones?
Afternoon. Thank you for coming. I think you know that I'm a general counsel, so I'm transactional, unlike several of my colleagues who are litigators.
Right.
So I am constantly in my own life trying to find ways to solve problems that does not necessarily include the court system. That is by no means meant to be a negative comment, but rather just a fact. Your opening comment regarding the abhorrent things that may have occurred or probably did occur, I absolutely agree with you. One of the things we heard in subcommittee that I'm sure you weren't there for, is it was interesting as we learned that different states opened up the gates, that there was, let's just say, a sprint to the courthouse. And then in terms of the number of lawsuits that were brought, and then of course with the absence of capital to be able to come behind such a number of lawsuits. And that immediately brings into my mind equity, and equity and fairness. And so one of the things that I just heard you say to the chairman 10 minutes ago, that you're asking for the ability to review and maybe even go back to your members. What I'd like for you to be thinking about, and I'd like to ask you what your initial impression is I see a way to address this issue not through litigation, but rather through a trust fund. A trust fund made up of, I'll say, entities that are either known or could be known through reasonable discovery that they likely, or more than likely, and pardon me for not using all the legal language, I'll use lay language, would be on the other side of the V. And being able to set that up, we put ourselves in a position, I believe, that we can start to address these, as you say, abhorrent issues that occurred, and being able to administer the money in such a way that it has the highest impact to ensure that these individuals are cared for, not just for any type of mental health, but also through some type of compensation and things like that, but not necessarily having to run that way. And I'd love to get your reaction to that, and love to see if you'd be willing to have that conversation with your folks.
I'm willing to have any conversation with our folks. I think one thing that we look for with at least city government is we want them to be good financial stewards of the taxpayer money. So if they're being good financial stewards, they're not working effectively paycheck to paycheck as a local government. So they hopefully would set aside money for potential bad acts that might have happened in the recent past. I think when you start looking back into long-term issues over the past few decades, it gets a little more difficult because things get forgotten, things just disappear, and that makes it a lot harder to gauge.
To Representative Clark's defense, we have had several discussions about changes to the bill, and he's shared several of them with you today. Some are not included in here because we discussed them through. One that I, however, brought up was this distinction between private and public entities, and were we going to treat them the same with this law? Because the concept of harm to children by negligence, I guess I'll use that word, by people in charge of taking care of them, when you compare the number of kids taken care of by public entities, whether they be recreation departments or public schools, it dwarfs the number of private entities. The real amount of children out there that could have been harmed just by sheer numbers were not under the care of private entities for the most part. I think is a fair statement. They were under the care of public entities. So are we going to treat those kids differently than we do the kids that happen to be somewhere else? And that is a question that I wanted us to think about here in this committee, and it was at my urging that Representative Clark considered whether or not he would put that in the sub so that we would have a discussion about it. So to the extent that anybody gets mad at you, you can tell them it was my fault. I think it's what I just said for having this discussion. But we had this discussion previously when the subcommittee met and in previous iterations of this over the past several years. But I wanted us to have that discussion today too. Did you want to say something about that, Representative Clark?
And it is my intent to try to treat any victim and allow them to have justice, whether public or private. And in the original bill, the definition of entity was public or private, but through conversation, the sovereign immunity issue came up, and that's what we're trying to address. To Representative Jones's point, I don't know if establishing a trust, since our meeting in November, there's been some developments with the Boy Scouts of America. And I don't know if establishing a trust,
Specifically a bankruptcy.
a bankruptcy. And I don't know if establishing a trust would help the victims in that instance, because one of the things that a bankruptcy judge will use to stack the claims to pay out to the victims is the strength of the state's laws for the victims in this instance. And that is one reason why I believe that we as a legislature need to, some of the conversation going on earlier, do we wait and see? I think that's one of the reasons why we need to act, because even with victims whose statute of limitations have not expired, in that case would be at a disadvantage with other states to get the claims that they are owed. So that's why I would think that we would need to move, maybe address some changes that's been brought up today, but those are just some of my comments, Mr. Chairman, and to Representative Jones.
Representative Jones.
So, Chairman Clark, thank you. I appreciate that. And what I'm proffering, I hope that you understand, and I understand your point, is whenever we're faced with such a task, and this is a monumental task, I think everyone in the room would agree with that. All I'm asking is can we consider every possible avenue to solve this the most efficient way? And I understand I proffered something that I think just needs to be looked at, and that's what I'm asking for. Thank you.
Ms. Oliver.
I think your idea is a good one to explore, specifically because of the bankruptcy, but also I'm aware in other states that there have been, I believe the Catholic Church in either Pennsylvania or New York is established. There's a lot of movement along the lines you're discussing, which is very valid to discuss in a lot of different reasons. And we see that model in the gymnastics Olympic case, for instance. And so that model is becoming more and more but Representative Clark is right. We've got to get in line. And we are preventing victims from getting in that line without passing this bill.
I'm not sure that we're preventing them, but the question is, what will they be? Where will they stand in priority of their limited funds to be divvied up? They'll be in that line. And the concept that we don't know for sure is, how will the bankruptcy court treat the victims from the different states? Will they use a standard that I think may have been used before, and that is, what is the law in that state, and am I going to treat them that way, or will they just treat them all the same? We don't know the answer to that question.
We don't know the answer, and I'm not going to pretend to speculate about that, but I do think that this is a national issue, and there are national entities. There are local issues too, local private schools, but we have to allow our victims to proceed in the national discussion.
And along this part of the discussion where a lot of stuff's going on right now,
Exactly.
The subcommittee members will also know, when we had meetings last year, the Attorney General came and testified, and he talked about a study that he has undertaken with the Prosecuting Attorneys Council to go through all the cases and files of the Catholic Church and to come back with recommendations to them as to what needs to be changed and what may need to be addressed. So that's another piece of the puzzle that we don't have with us right now, including the court action that is pending in Georgia as well. Yes, sir.
I just want to add something from this discussion about bankruptcies, just to remind everyone, municipal governments in Georgia can't declare bankruptcy. But if
unless the legislature allows them.
Unless you allow us, yes. But if a city does have an issue financially, they could be dissolved, and then what we owe ends up becoming a burden of the county that we're in, which obviously becomes more complicated if a city's in multiple counties.
And the concept we have in sovereign immunity issues with the local governments that sometimes we waive sovereign immunity up to the extent of their insurance coverage.
Right.
And we do that so that they don't have to, quote unquote, sell the fire station
That's exactly
in order
right.
to pay the bill, because that would arguably inhibit public safety more than addressing the wrong that was done there. So what I would ask you to do, Mr. Patel, is think about
Sure.
this issue and as to how, if we were going to say waive it up to the limits of insurance, how language could be constructed, and how we also might deal with the ante litem notice.
Okay. Be glad to.
If we do something to you, so to speak, we'd rather do it in the best way possible rather than do it in such a way that harms you more than was ever intended. If that helps any.
I appreciate it. I'd be glad to.
Thank you, sir.
Thank you.
Larry Ramsey. Mr. Ramsey, welcome. Good to see you today. Please tell us who you're with, and we'd be happy to hear from you.
Thank you, Mr. Chairman. Larry Ramsey with ACCG, and thanks to Mr. Patel for covering pretty much all the grounds I will, so I'll be real short. I appreciate the discussion here, and particularly the last comment. One of the things I was going to speak to, as the chairman referred to the limits of insurance, one of the comments I was going to make, and it in no way relates to the underlying activities that we're trying to get at here, but just in the governmental context of who pays. Ultimately it's the taxpayer that pays. But on the insurance piece, I would just point out that I would say that most counties are insured through our insurance program, and I'd say most cities are insured through theirs. I would doubt, I'm pretty comfortable, at least on the county side, we don't currently have an insurance product that would cover activities from many years ago. And so we would be looking at right now probably an uninsured liability. And that's something that the discussion that the chairman mentioned that I think is something that we with GMA and with the committee can continue to look at. How do we address that issue to the extent we're going to be looking at an insurance issue against these type of liabilities? That's something that we'll have to factor in, is that particular piece. The only other comment I was going to make that hasn't already been covered is just the language about the waiver at the end of the bill, the reference to governmental immunity. I would just suggest that's a bit vague. I don't think that's a defined term. There, as I'm sure you know, there are many different immunities in law and Constitution. This could refer to official immunity, which is with respect to individual actors, officers, and employees of government. That's a constitutional immunity, and I'm not sure how much that could be altered by statute. But then we have legislative immunity and judicial immunity and prosecutorial immunity. Just a point that I think that maybe is a term that would need more fleshing out as this moves forward. But otherwise, I'm again happy to work with the committee and with GMA and Mr. Patel to address the issues that have been identified, and happy to try to answer any questions you may have for me.
And we would appreciate some language from you.
Yeah. Thank you, Mr. Chairman.
Okay, thank you. Mark, tell me your last name, Mark.
Barons.
Barons.
Thank you, Mr. Chairman.
Like Barrons.
I wish they spelled it that way.
Okay.
The only place they seem to get it right is in Chicago and Germany. But
Please introduce yourself, and we're happy to hear from you.
thank you very much. My name is Mark Barons. I'm a lawyer with a firm called Shook, Hardy and Bacon in Washington, D.C., and I'm here today on behalf of the American Tort Reform Association. ATRA is a broad-based coalition of businesses of all different size, service providers and nonprofits. And ATRA's core mission is to focus on predictability and consistency in the law. This is a very difficult subject. I've been to other states and seen this. I've seen many victims. You can't help but feel empathy for the people that have been subject of abuse. But ATRA has to look at this under our principles and say, are we about the rule of law, regardless of how difficult the circumstances in which the facts might arise? And so ATRA's board has looked at this and said, look, if we're about the rule of law, if we're about predictability and consistency in the law, then we have to be consistent in that position. And that means coming in and testifying on difficult cases like this one. I've only had just today to look at this, so I wish I could be a better witness in terms of looking at the bill, but my reaction in looking at it is that while a lot of work seems to have been done, that it needs more work and it needs further study. In looking at it, there are a lot of terms in here that seem subtle that I think are going to have a very significant impact if this is enacted, maybe impacts that the committee hasn't foreseen. For example, just looking at on the first page, where it expands the discovery rule to 4 years, okay, that by itself isn't so bad, but then it strikes out here, the discovery period is to injury and it strikes to the plaintiff. So now all of a sudden you're not limiting the lawsuits or giving more time to the person that's the victim in the case. It could be anybody. Are we now saying that parents have a cause of action if their child was abused? Do grandparents have a cause of action? What about a spouse? If you have an adult who in adulthood realizes that they were abused as a child and have anxiety or depression or other manifests of what happened to them as a child, now does the spouse have a right to bring a claim? I don't know that other states have gone this far at all. I'm not aware of any that have, but this is by a little word change, a very dramatic change in Georgia law. The prospectively abolishing the statute of limitations. I'll go to page 2. A plaintiff who's between age 23 and 52 may bring a cause civil action for recovery of damages. Okay, so we're now saying prospectively, I assume there's no statute of limitations if the plaintiff is between the ages of 23 and 52. Does that mean if they discovered the conduct and they knew it happened, that they don't have to file now within 4 years? They can sit on it for 10 or 20 if they want to, until the witnesses are gone and the documents no longer exist and there's nobody to rebut the claim? That seems to see what I see here. Maybe that wasn't the intent. That's what I read the language to say. You go on to look at the reviver language. The definition here, it says, you got 1 year to sue. We're going to open the window to sue, and that would include a person.
What line are you on now, Mark?
I'm sorry, page 3, Mr. Chairman. I'm just looking at line 73.
Okay. Go ahead.
Where now the bill says there's a 1 year window to bring these lawsuits against a person who had responsibility for the care of the plaintiff. Person is defined in line 61 as the perpetrator. But responsibility of care starts talking about a person who's a volunteer who owed a duty of care to the plaintiff. That's not talking about a perpetrator anymore. That's talking about somebody who has responsibility for the plaintiff's care. Let's say it's a church and you have an assistant pastor maybe that's accused of bad acts. Are we now saying the deacon of the church is personally liable? Personally liable, because they fit within this exception and there's a 1 year window to go after them individually. Are we now saying that if a teacher does something, that no longer is it just the teacher that is the target or the school district, but now the principal, because the principal has a duty of care to the child? How person is defined here is very unclear, and it can have very dramatic impacts. The legislator that was here was talking about, who stepped out, was talking about the concealment standard. You can sue an entity that allegedly engaged in concealing. But there's no definition here that says concealment has to be done with the intent of destroying information that the plaintiff is basing on. Concealment could just be following the document retention policy that was in existence, right? We talked about, well, there is always, we're looking at the intent of the person that destroyed the documents. The bill doesn't say that. The bill just says if you concealed, you withheld information. So let's just assume that the church or the school district or whatever the entity has a 10-year document retention plan. Most of these acts occurred decades ago. They all would have instituted their plan by now. Are you saying that basically anybody is per se guilty of concealment simply because they followed their standard document retention policy? There's nothing in here that ties the destruction of the document to the intent to conceal information for purposes of avoiding liability in a lawsuit. And it's a negligence standard that applies. So I look at a lot of these things here. Also, liability can be against the organization if the person was allowed to continue working in a paid or volunteer position. So let's say that an accusation is made against an assistant pastor or a Sunday school teacher, and the school, they're not quite sure. They talk to both sides. The truth is unclear, but they say, you know what? We're not going to allow sort of the one bite, the one bite rule. Now we're not sure what happened, but we're going to make sure that that person is removed from Sunday school teaching children. They can stay employed, but we're going to put them in a setting where they're no longer around children. Have they now still engaged in a position where they've continued working in a paid position, even though they did what they thought was the right thing to do? A lot of these things, again, you read it, and any good lawyer, I looked at this in 15 minutes today, and I can pick these things apart and just show how things that on their face look innocuous are broad enough to drive a truck through. And it's going to impact entities here in the state. And then, finally I look at the language, and you've got, further reviver, and then the question about the impact on sovereign immunity. And let me talk about reviver generally, and I know we're pressed for time, about why reviver is sort of, that's probably what you're most focused on, and why it's so significant.
Tell us what line you're on now.
I'm just talking generally about the reviver parts that are in page 3, beginning at line 68 and through the end. And then at the end, on page 4, beginning at line 102, there's a permanent reviver here. Permanent reviver. It's not a one-year window anymore, but anytime you can show that the entity engaged in intentional or conscious indifference of concealment of the abuse. And again, it's not for the purpose of preventing the information from coming out. It could have been that they had evidence of the abuse 40 years ago, and 12 years after that, they followed their document retention plan and destroyed the documents. Nobody would have expected in 1950 that they needed to have documents in 2021. So that could be evidence of intentional concealment, and now there's a permanent reviver window allowed the entity. The problem that our members face in these cases, apart from the rule of law issue, is that by definition these acts are occurring in private. They're not occurring generally in open. You have one person, and oftentimes a huge age discrepancy. I was at a conference a couple of weeks ago, and there was a person on my panel who runs one of these companies that runs ads on TV to generate these lawsuits. And he said the average plaintiff was, I think it was close to 60 years old. Well, if a person was a child and now they're age 60, that means the perpetrator is probably dead or they're in their 90s. So what you have is a situation where it's not he said, she said, it's he said, and on the other side, you don't have a witness who can provide the other side of the story. Now, we have to assume every victim is telling their truth. But there are always two sides to the story. And in the reviver context, because of the age of these claims, when they happened and how old the folks are now, it becomes practically impossible to put on a defense, because the person who's being accused is probably not there to say what their version of the story is. The documents that may have been created contemporaneous to the event don't exist anymore. Other witnesses that can say what they saw or heard at the time are unavailable or don't exist anymore. It becomes almost practically impossible to defend these cases. And you're going to see a lot of cases if this happens. Just to give you an example, New York last year passed a reviver. USA Today described the day after the New York law took effect as a legal free-for-all. There were 427 revived claims filed the next day. By the end of last year, over 1,300 cases were filed. In New York City alone, they have 45 judges assigned in each borough Each borough has designated judges to decide these cases. They have 45 judges assigned to preside over the litigation. The liability of one church alone is expected to be between 1.8 billion and 6 billion for revived cases in New York, New Jersey, and California. And already the Diocese of Rochester has already filed bankruptcy. The financial impacts are going to be enormous in your state. And when you start talking about the schools or churches or the Boy Scouts, if the money all goes here, it's not going to be available for other beneficial social programs. It's not going to be there for early childhood education. It's not going to be there to feed the poor or whatever the beneficial programs that they're doing. So there are impacts here. And then finally, ATRA is concerned about the precedent that sets. I'm a tort lawyer, tort defense lawyer, and I see it's sad, but if you do product liability work, it's difficult to do. I have a lot of respect for the people on the plaintiff's side. They represent people and they all have difficult stories. And on the defense side, they do too. And it becomes very difficult where you have people that have suffered a terrible tragedy. But where do you start to draw the line? I think it's a dangerous thing when the legislature starts making moral judgments about which injuries are more significant or more important than others. Do you now say, why do you say that this is more important than somebody that's dying of mesothelioma, that's been diagnosed and is going to die in 6 months? Or somebody that has third-degree burns over most of their body, or somebody that has suffered a reproductive harm and can't have children? All tort cases are tragic, including these. And one concern is you start going down the road of creating special exceptions. And it becomes very difficult for you to tell people when they come to you with the next mass tort, and they want special treatment too. How do you say to them, no? And I'd be happy to answer any questions that the committee might have.
Okay. Ms. Oliver?
I notice you have a Georgia lobbying tag, but you said you were from a Washington, D.C. firm.
Yes.
Are you here on this issue nationally? Are you
ATRA, so I'm here representing the American Tort Reform Association, ATRA, and yes, we are working against legislation across the country that is going to affect our core principles of eroding predictability and consistency in the law.
So it was a national group that paid for you to come, not a Georgia group today? I'm just curious.
I'm sure they have Georgia members. I don't know who their donors are or where they get their money. It's a national organization with businesses of all different sizes from all over the country, and I know that there are Georgia members. I couldn't identify them specifically. But we're all concerned, all of the members are concerned about the precedential value that this would have beyond those that would be directly affected by the bill.
Representative Clark, did you have a question?
She was going to respond.
Professor?
I don't have any questions, so I can wait to clarify just a few things, just based on our studies and research that we've done at University of Georgia.
Okay. Hold on, I don't have your mic on. Did you have another question, Representative Oliver?
14 cases is what was your adjective, your hyperbole adjective? Is 14 cases too many?
Her point is that I think your point is that when we opened the window to persons, not entities, there was around a dozen. I thought I would have said a couple of dozen, but cases filed. So her point is that when we opened a window against the person, not entities, a few years back, the cases were not as great as maybe some might have anticipated.
I think that when you include the entities, that the outcome would be very different than that.
And your example was because that's what New York
That's
did.
what we've seen in other states.
Okay. Okay. Thank you for being here today.
Thank you very much.
Yes, sir. We appreciate it. Mike Griffith? Mike, welcome. Good to see you today.
Thank you, Mr. Chairman,
Yeah.
for this opportunity.
Tell us who you're with, and we'd be happy to hear from you.
All right, my name is Mike Griffin. I'm Public Affairs Representative with the Georgia Baptist Mission Board, and we represent almost 3,600 churches here in our state, and we've had an opportunity to, to support this kind of legislation since 2015. We supported the 2018 Hidden Predator Act. And, we believe, and the reason we do is that we believe that victims are number one. In other words, that's where our focus needs to be. And we've worked hard at child protection because one of the greatest ways we can work with victims is to make sure we don't have them. And so, in coming on full time now with Georgia Baptist since the first of the year, one of my dedicated tasks is on child protection because I've worked so much with this. And I worked very closely with Representative Spencer when he was working through this legislation and helped him with the 2018 bill that failed and didn't end up making it through. It did the House. And, when I would meet with him, I was sharing with him what our concerns were. One of the, and being down here 13 years lobbying, one of the most dangerous things, other than the intent of some laws that we just simply don't like anyway, are the unintended consequences. And that's where you have to really watch. And so in the last 5 years, I've had an opportunity to become a little more educated about these issues, and the dangers that are there are on the unintended sides. And working with Representative Spencer, I had an opportunity to say, as Georgia Baptist, we support this. But here are some things that we're concerned about. And we want to make sure that the evidence, and especially on the look-backs, is that there was indeed a duty of care. And we talked about that today. Number two, that there was knowledge of a perpetrator or incidents that actually did take place. They knew it. And thirdly, was there willful, intentional cover-up? And we felt like with those kinds of high standards, we would not be as worried about how far back you want to go. You can go 100 years. I mean, because that's going to be hard even for the victim to be able to bring up that kind of evidence. And in working closely with victim assistance, realizing this can be as difficult on the victim as it is anybody else trying to go back and have to sit through hearings. So we recognize that many of these victims, they're not even going to begin to approach this unless they really think there's really some serious reason why they think this is going to be beneficial. However, and I have talked with others as well, that we don't want to produce a ambulance chaser kind of bill where people are using victims to make money off of them either. We don't want to see that happen to our victims that are out here. And so we want to see reasonable things that are done. And we also are always concerned that it would be clear and convincing evidence, not just preponderance. So that, in other words, it wouldn't give reason for people to come forward or be manipulated by somebody that has another interest other than justice behind it. Now, representing Georgia Baptists are different for a lot of reasons. Some of them good, some bad, I guess some people would think. But we're a bottom up. We're not a top down. We believe in church autonomy. And so we can't tell our churches what to do by way of any authority. And actually it works the other way around. And that's not an excuse. That's a reason why we can't do more. But it's also us to understand the fact that these kinds of organizational policies about keeping records, doing away with records, it's just simply not there, because you're going out in rural Georgia out here, and we want to make sure that you're going to go back 47 years now.
I could tell you what I'd like for us to focus on today, and you touched on it about the clear and convincing evidence.
Right.
I was kind of wanting to focus today on the law in front of us and the details of the bill and changes people might like to be seeing. You've appeared here every time we've had a hearing,
Sure.
to the best of my knowledge, to voice support for
Right.
this type of legislation, and
Yes,
and
sir.
we understand that and appreciate that.
Yeah.
But I do want to give you a chance to wrap up.
Yes, sir. And so the going backwards, that's our concern. We know, again, we're as long as the evidence is there, that's different. But we know that 2012 was the last time there was a change or an amending of the law of reporting. We know that 15, 20, even if you go back 20 years, there's a good possibility churches are going to have that, and they're going to have the insurance to cover it. You go beyond that, there may not even be people alive anymore. So we just want to make sure that some of those unintended consequences are not there. And again, we want to work in a very positive way to help the committee in any way we can.
And you have, and we appreciate that.
And we will continue. Thank you. Thank
Frank?
you, Mr. Chairman.
And Frank, I call you Frank because now I'm going to tip the last name Mulcahy. Mulcahy.
Like my uncle, Father Mulcahy on MASH.
Good to have you today. Please tell us who you
Okay.
represent. And as I mentioned to
Yes.
Mike, our focus today, I wanted to be really on the words and the law. But we're happy to hear from you, though.
Yes, thank you, Mr. Chairman, members of the committee. I'm Frank Mulcahy. I'm Executive Director of the Georgia Catholic Conference, and I represent the Catholic Bishops of Georgia. And I was pleased to appear in the November meeting and talk about what we have done really since 2002. That's kind of our benchmark of when we have done things. And I provided documents, which are on our website. If anyone would like them, they're certainly still available. Second thing I wanted to mention, and Chairman, I think you mentioned it earlier, we are currently involved in a file review by the Prosecuting Attorneys Council with the direction of the Attorney General, and it is progressing. I don't know of any problems with it. We're giving full disclosure of all of our documents related to abuse of priests to the government, and the MOU that we're under does require a report. I'm guessing, because I can't control it, but I'm guessing it will be late summer, just the way it's going. All right, with regard to, and I don't know any more to tell you than that, so I have no real update. A couple of items, and some of which I'm trying not to repeat. A number of things that were talked about today, but a couple of things I think are important. And I may disagree with Mr. Patel, and I understand his position with regard to the cities and counties. But at the same time, we think it's important that we focus on the victims and to say private entities are going to have to be accountable. Public entities are not, or are going to be on a different standard. And to do that, one, I know we need waiver of sovereign immunity. I don't think that the two-line phrase in the substitute bill is sufficient to do that, but we're happy to work with language to make sure it does. The second thing is the ante-litem notice. There's no reference to that. I think that's a more difficult problem than maybe even sovereign immunity. But I do think that's important because that could just knock out.
I think we would simply have
all
to say that
claims.
the ante-litem notice is not applicable in some form or fashion.
Yeah.
But I'm with
And
you.
again, the other thing I notice in that provision is it seems to apply only to the window period. Now, whether that was intentional or not, I don't know, because it refers to purposes of this subsection as opposed to this code section. And I think if we're going to have waiver of sovereign immunity, it should be to claims that come out today, last week, last month, 10 years ago, just to be on an even keel with private industry and nonprofits. I'm going to disagree with Ms. Hetherington on sections related to concealment, and that's lines 80 through 92. She says she thinks that's more restrictive. I would disagree. I think it is more expansive, particularly when we're going back to 1973. I don't think you could find law from the 1970s or 80s or 90s with these definitions of concealment. Some of them are very specific, and I get some of the specifics, but things like harboring is an extremely broad term. And it can cover a lot of things which were probably not intended. Let me give you one example of not kicking somebody to the door. This is an obligation which we have in the Catholic Church towards our priests, is we don't kick them to the door. And we look to make sure they're not going to be harming anyone in an abusive situation. But at the same time, if there is treatment, we try to get them treatment at our expense. Now, back in the 70s and 80s, maybe even the 90s, if you went to take a priest or anyone to a psychiatrist or a psychologist, and they come back and say, you know, we talked to Father so-and-so and he's cured. Now, we know today that's virtually impossible to cure a pedophiliac person. And so we would never put someone like that back in ministry. But we didn't know that at the time. So some people did go back into ministry that never should have gone back. But we would be involved in concealing that under this definition, even though what we did was to try to help the person and try to help the church as well. So I think that does need some additional work. Let me see what else I had here that was. I think I've covered all the points that were not already made. Except for one point, Representative Jones, you raised a very interesting question, which we have considered and discussed with regard to setting up some kind of a fund. One of the problems we have in Georgia with a fund is making that fund basically a replacement for trial by jury. And you know, when the Medical Association back 15 years ago or so tried to put a cap on punitive damages, the court knocked it down. If we can find a way to have a fund or some sort of a resolution process that would end the situation, I think we'd be interested in talking about that. Now, someone mentioned some other dioceses in the United States have set up some voluntary
We'll give you just
funds.
a minute to wrap it up.
Yeah.
Okay.
So we have some voluntary processes, but they're only voluntary. And it wouldn't cap, well, it could, but you have a lot of people saying, don't do it. So I think I've covered my major points. Again,
Thank you.
Mr. Chair, but happy to work with you, with Representative Clark, and try to work something out that helps kids in particular, but everyone in general.
We appreciate you being here today. Thank you.
Okay, thank you, Mr. Chair.
So here's where we are. I laughingly thought that we would spend an hour talking about this. When does that happen in House Judiciary Committee? Many of you are sending me texts about other meetings that you're supposed to be at, and I as well. So what I'm going to do at this point is I wanted to air out the new language. I wanted everybody to have a chance to hear it, particularly y'all. And what I'm going to ask you to do now, Representative Clark, is to take these comments, criticisms, remarks that you've heard today and try to come back and tell us if you want to make changes to that and present another sub to us that takes into account the discussions that we had today. So, yes, ma'am.
I just wondered that you were going to put a timetable. I wondered if you were going to put a timetable on that and come back ready to.
Monday. Monday, yes. Mm-hmm. So, and that goes as well with all the other entities, the folks that came today and testified and had questions about that. You have okay. So that's what I would ask you to do. The chair is open to talk with you about that. I'm welcome to talk to other members of the committee about this. I am torn with the idea of doing something now versus waiting for some of these other things that we've talked about that have come about. And I also realize the arguments of why we need to do something now. So those are the kind of things I would like your input about as we move ahead. So what we're going to do at this point is stand adjourned. And for those of you that I said I would try to get this over sooner rather than later, I apologize because I know you had other places and committees to be. Thank you.